Hello, yes, Luminta?
You can start.
Good evening, ladies and gentlemen. Welcome to the OPA's seminar on the topic of legal impacts on social media and telecommunication way forward. We would like to warmly welcome you for this webinar, Zoom webinar, which is jointly organized by the Social Events Outreach Programs and Young Professionals Committee of the Organization of Professional Associations of Sri Lanka and Electrical, Electronics and Telecommunication Sectional Committee of the Institute of Engineers, Sri Lanka. To begin the proceedings, I would like to introduce our President of the Organization of Professional Associations of Sri Lanka, Mr. Saman Varusavitana, who would do the welcome address for this webinar. Mr. Saman Varusavitana graduated from the University of Runa in 1987 as a Bachelor of Science in Agriculture, specializing agriculture engineering. He obtained his postgraduate qualifications in environmental engineering from the University of Moratuwa and in business administration from the University of Colombo. In 1988, he started his career as a research officer in then what we call the Ceylon Institute of Scientific and Industrial Research, which is known as CISIR, and moved to plant protection industry and held many senior positions in private sector organizations, such as Haley's Group of Companies, James Finlay Limited, and Chemical Industries Colombo Limited. He is presently a plant protection and environmental health consultant and also the Chief Executive Officer of John Piper International Private Limited, which is a leading pest management and environmental services company. Mr. Varusavitana is a former secretary to the Sri Lanka Crop Protection Association, and he is the current program secretary of Sri Lanka Institute of Agriculture, formerly known as Sri Lanka Organization of Agriculture Professionals. He has been serving on the Executive Council of the Institute since 2005. In OPA, he has been serving on OPA Forum and the Executive Council since 2008, holding many positions such as Representative Member for Agriculture Profession, Assistant Treasurer, and Assistant Secretary, as he was the 43rd General Secretary of the Organization of Professional Associations of Sri Lanka. Without much ado, may I invite Mr. Varusavitana to do his welcome address. Over to you, sir. Thank you.
Thank you, Dulita, for the kind introduction. Let me also once again welcome all of you who have joined this webinar organized by Organization of Professional Association of Sri Lanka, OPA, jointly with the Iesl Electrical and Electronic Telecommunication Security Committee. I warmly welcome all once again for the legal impact of social media and telecommunication, the way forward. That's the theme today. And this is a timely topic because it is social media and the telecommunications are highly used, especially after the COVID-19 pandemic. We were forced to embrace the technology in a very aggressive manner. And everybody is trying to use the virtual platforms and various other telecommunication and electronic platforms for the communication and so on and so forth. So simultaneously, the issues with regard to the legal and other social, cultural, and political impact, it is enormous. So I believe this is a great, it's a right time to talk about very seriously about these matters. And we have been conducting a series of seminars, and Mr. Sunil Abhiratna and all joined in this seminars last few months. And we have invited very eminent speakers today. Let me welcome Mr. Oshada Senanayaka, who is the Director General Telecommunication Regulatory Commission of Sri Lanka. He will join a little late because he's got some commitment with actually the President right now. In advance, I want to welcome him. And Mrs. Tarilika de Livera, the Director, Compliance, Telecommunication Regulatory Commission of Sri Lanka. Welcome you, Madam, and we are honored and grateful to you to be here with us and to share your insights and knowledge and experience with us. And our next presenter, actually, Mr. Sunil Aberatna, our very own member and Senior Attorney at Law, Co-Chairman of IT Committee Law Asia, and CEO IT Committee of Iesl, Chairman IT Lawyers Skills of Sri Lanka. He's a well-known figure and he's also our OPA member. And we welcome you, Sunil, and it's great to have you here. And we have here few others with us, our General Secretary, Madam Ruchira Gunasekara of OPA, and Dr. Naresha Samarasekara, Vice President OPA, Chairman Social Events Outreach Programs and Young Professional Committee of OPA, who's leading that committee and is the initiator of that committee. And also the Engineer Chamil Edurumani, the Assistant Secretary of OPA, Chairman, Electrical and Electronic Communication Sectoral Committee of Iesl, and also convener of the Social Events and Outreach and Young Professional Committee of OPA. And let me welcome once again all of you who have joined this panel and speakers. And especially I must mention our moderator. I will give the formal introduction to Mr. Dulitha Pereira, is also our very own member. So I'd like to warmly welcome who have joined this seminar physically in the OPA and also online. All the members, all the professionals and all who are attendees, let me welcome all of you very warmly on behalf of OPA and on behalf of these two committees. So I believe this is a very important topic that we are going to talk about. To take this over, to have this discussion, we have our moderator, Mr. Dulitha Pereira. If I introduce Dulitha Pereira, he's a chartered accountant by profession and is a partner of KPMG, Sri Lanka. He has experience of more than 26 years and 22 years of experience of practice in numerous global and regional projects. Dulitha is also a former Vice President of OPA and also the Treasurer of OPA. He's a member of Executive Council and the Forum of Organization Professionals Association right now. So before handing over to Dulitha, I must say that we, OPA, have 52 member associations across the country. And we represent 32 professions. Actually, we established our organization in 1975 with the aim of helping the government to give the policy the proposals, policy advisors. So we are strengthened with diverse professionals. I believe this opportunity, we can disseminate this knowledge among our professionals, and also they can in turn give this knowledge to all the public who need this very need information. So with that, I'd like to hand over to Mr. Dulitha Pereira, our moderator. Over to you, Dulitha. Thank you.
Thank you very much, sir. Next item in our agenda is for the opening remarks by our own Dr. Naresha Samarasekara, who has done yeoman service to our organization. He is the chairman of the Social Events Outreach Programs and Young Professionals Committee, and also a vice president of Organization of Professional Associations of Sri Lanka. He's a dental surgeon at the Lade Ridgeway Hospital for Children in Colombo. He's also the vice president of Sri Lanka Dental Association and an honorary treasurer of the Government Dental Surgeons Association. He's also the chairman of the Social Events Outreach Program and the Young Professionals Committee, and also vice president of our OPA, A lot of our members know the amount of involvement he have had in various activities in the OPA and needs less introduction. So with that, I would like to invite Dr. Naresha Samarasekara to make his opening remarks. Over to you, Doctor.
Thank you, Dulita. Good evening, ladies and gentlemen. Social media cannot be ignored. Let's face it, social media has become an integral part of our lives. Whether it's Facebook, Instagram, or other means, people are taking advantage of these online meetings, spaces to make friends, communicate, and expand business opportunities. Nowadays, in crisis situations, technological advances are transforming and disseminating information to the affected communities in the fastest and easiest ways. The majority of people using social media are decent, intelligent, and inspiring. The problem comes with a small minority who spoil it for everyone else. Social media users don't enjoy any of these immunities granted to social networking sites under the law, so they should be careful when posting messages or files to the sites. But what are the legal obligations that arise out of use of social networks, both for the user and the site themselves? The main areas where users can get themselves into trouble are through the posting of defamatory content and content that infringes on intellectual property rights. We are aware that in recent years, there has been an increase in calls globally for greater regulation of social media performances, and including in Sri Lanka. In this respect, the way in which social media companies address hate speech on their platforms is a particularly burning issue for governments, policymakers, regulatory bodies, self-regulatory institutions, media, civil society, and public at large. Under these circumstances, we are hosting this webinar today on legal impact on social media and telecommunication, the way forward, organized jointly by social events, outreach programs, and young professionals committee of the OPA and electrical, electronic, telecommunication sectional committee of Institute of Iesl. Today, invited eminent panelists are Mr. Oshada Senanayaka, Director General Telecommunication Regulation Commission of Sri Lanka, Mrs. Haralika Livera, Director Compliance of Telecommunication Regulations Commission of Sri Lanka, and Chairman of IT Committee of Bar Association of Sri Lanka, Senior Attorney at Law, Mr. Sunil Aberatna, to share their expertise and experiences with us and to discuss the way forward. And on behalf of the OPA, finally, I warmly welcome them. Thank you. Over to you, Linda.
Thank you very much, Doctor, for those opening remarks. Next up in our agenda is to do the IESL, Institute of Engineers of Sri Lanka introductory remarks. For that, I have the pleasure in introducing you Engineer Chamil Edirimuni. Mr. Chamil Edirimuni is an electrical engineer of Ceylon Electricity Board. He's the Chairman, Electrical Electronics and Telecommunication Sectional Committee of the Institution of Engineers of Sri Lanka. He's also a council member of the Institution of Engineers of Sri Lanka, and he's an executive committee member and former secretary of CED Engineers Union. He's also the convener of social events, outreach programs, and young professionals committee, and the assistant secretary of the OPA. Without much ado, may I invite Engineer Chamil Edirimuni to make IESL introductory remarks. Over to you, Chamil.
Thank you, Mr. Dulita, for interrupting me. The topic is much important to the engineers, and also the other professionals, and also the public. So this is a timely topic. So before going into my opening remarks, let me just brief you what is Iesl. Iesl is the Institution of Engineers Sri Lanka. So it has been formed in 1906 as the Engineering Association of Ceylon. And when it comes to 1956, it was reconstituted as the Institute of Ceylon. Then in 1996, the name was changed as the Institution of Engineers Sri Lanka by the Act number 17 of 1968. So that is a brief of what is Iesl is. And our main objective is to be among the leading professional institutions in engineering and technology in the world. So our council, which has about 32 seats, is leading the operation of the institution. So coming into our sectional committee, electrical, electronic, and telecommunication committee. So it has about, so our sector has about 3,300 engineers, out of which about 100 are chartered engineers. So the topic, legal impact of social media and telecommunication way forward, is pretty much useful to all of us, because we are using these social media and telecommunication tools in our professional affairs, and even in our job scope, and even we do coding, and we do everything with this internet, IoT, and all others. So I hope you can join throughout this webinar with our eminent panelists, so that you will gain much knowledge about the sector. And I hope you will have a wonderful session with all of us. Thank you.
Thank you, Chamil, for that introductory remarks from the IESL. Next is our hello. Sorry, the mic was on mute. It's on the now the topic, the main topic of our webinar, legal impact on social media and telecommunication, the way forward. Let me introduce the presenter today. Unfortunately, our main presenter, Mr. Oshada Senanayake, had an urgent commitment for which he had to step out, and he was unable to make it for the presentation, but he has entrusted that task to a able colleague of hers, who is none other than Mrs. Carlica Oliveira, who is Director Acting Compliance of the Telecommunication Regulatory Commission of Sri Lanka. She has 26 years of service in Telecommunication Regulatory Commission in Sri Lanka. From a qualification side, she's a BSc Engineering, Electrical and Electronics qualification from the University of Peradeniya, and she has a MSc in Electronics and Telecommunications from Sheffield Hallam University in UK. She is also a chartered engineer, a member of the Engineering Council of UK, member of IET UK, and associate member of the Institute of Engineers of Sri Lanka. She's the Vice Chairman of Asia Pacific Policy and Regulatory Forum, and she worked as a rapporteur for ITU D-Study Group on broadband study questions. She represented Sri Lanka in International Telecommunication Union and Asia Pacific Telecommunity meetings since 1994. Without much ado, may I invite Ms. Tharlika de Oliveira to make her presentation on this topical subject of the legal impact on social media and telecommunication, the way forward. Over to you, Tharlika. Please unmute, Tharlika. I did the same mistake earlier. Please unmute and speak. Thank you.
Thank you, Dulita, for your kind words. And good evening, all the people who joined this webinar. And first of all, I would like to thank OPA inviting me to join this webinar, because this is the first time that I'm with you. And without taking much time, I will go to the presentation. I'm sure, I think most of the people who joined this seminar today, webinar, and knows about the TRCSL, Telecommunications Regulatory Commission. But it's my duty. I will briefly explain about what the TRCSL is and what are our responsibilities. TRCSL is established under Parliament Act, and this is in 1991. It was earlier, it is the Telecommunications Authority. Then it was converted into an independent commission in 1996 with the Amendment Act. So TRCSL is the National Regulatory Agency for Telecommunications in Sri Lanka. It's a 5-member commission. So literally the chairman will be the secretary to the line ministry. Then Director General is the permanent member in the commission, and 3 other members in the fields of law, finance, and management. So TRCSL, by the Parliament Act, we have a Telecommunication Act. There we have 9 objectives, but I would like to mention few here, only 1 or 2, because this is relevant to our topic today, and this is very much important as consumers even, and as the industry. So the main objective is to ensure the provision of a reliable and efficient national and international services in Sri Lanka. Then the second one is to protect and promote the interest of consumers and purchasers and other users in receiving the telecommunication services in terms of quality, in terms of equipment, apparatus supplied. Then one of the main objective again is to promote, to maintain and to promote the effective competition between people who engage in commercial activities. Then the fourth one is to promote the rapid and sustained development. So these are the 4 objectives I have chosen out of 9, which will be important for our presentation today. Then we have duties and responsibilities as the National Regulatory Agency, which I have mentioned earlier, for the telecommunication industry in Sri Lanka. So we have 24 duties and responsibilities written in the Act. And out of that, I have chosen few. The most important thing is we will be granting licenses. So this is the main task that TRC is doing. Not TRC is granting licenses, but we will be advising minister to grant license. This is called the Section 17 license, where all the telecom operators, they have to have this license to operate a telecommunication system in the country. The second is to pay due regard to the public interest with regard to telecom services provided by these operators who have obtained the licenses from TRCSL. Then the third one is the determining tariff for telecommunication services and to approve the interconnection charges. Then goes to a few other duties and responsibilities. We do specify the technical standards. Then we approve the types of telecommunication apparatus. Then we, of course, we have prepared and we have implemented the QoS standards for the operators to operate their networks. And we monitor those standards, and we'll take necessary regulatory measures in that aspect. And we have to ensure the proper utilization of radio frequency spectrum. This is a vast area and a huge responsibilities in our shoulders when it comes to the regulatory agency for the Sri Lanka, managing the radio frequency spectrum, because we cannot do anything during this decade. We cannot do anything without the radio frequency spectrum. According to the topic, I will be touching the social media aspect as well. Not much, but less. But so everybody knows the social media is a new phenomenon that regulatory bodies taking in the world. And so the new channels introduced based on the social media request regulatory compliance in ensuring consumer protection. This is another area that my colleague speaker will be discussed in this meeting, in this webinar, because we are very happy. At the moment, we don't have I don't say a proper, but adequate law for the protection of consumers in this area. Then the cybercrime law and the data protection law will be in another couple of maybe weeks or months, but we have to be very happy. We will be getting these laws in place. So my colleague will discuss more about this. So then what's TRC's role in social media aspects? Of course, we received complaints. Of course, we are accepting the complaints. We received complaints on cyber harassment and impersonation online, and some other general complaints on social media. So what we do, if it is a harassment, then we will route it to the police cybercrime division. And if it is a general complaint, of course, we will route it to SL CERT. But here, in fact, I want to mention, especially the police cybercrime division, the amount of work and the quality and the credibility that they have taken, especially in handling all the social media complaints. We have to take our hats off to them, because they are doing a wonderful job within the limited law in place, and as well as the SL CERT. So these are the two agencies we are working with. But nevertheless, since why we have taken interest in, especially in social media complaints, because all these are on top of it's all our OTT players, and all these are working on top of the telecommunication network. So we can't just keep our eyes closed when these problems are arising. So we have taken interest in that area as well as, so what we can do, what we have to do, and what we can do. So since we have identified further trends in women harassment and abuse online, we have taken a long approach of creating awareness programs for children and parents. In fact, during this year, Women's Day, we have conducted several online programs, online awareness about the child harassment, cyber harassment, child abuse, impersonation. A lot of areas we have covered. And there was a very good response from the public for this, especially awareness to the children and parents, especially students. That definitely that worked well, because I can give you one example in this area. After this awareness campaign, the Director General received a direct email from a student, an advanced level student from a reputed girls' school in Colombo. And she was able to address directly to Director General. It was like, it's hard to see this. How can a student knows about the Director General of TRCSL to address a complaint about a Facebook, especially Facebook? It was hacked and some problem was arisen, and she said even her parents doesn't know that she's writing to TRCSL, and she was expecting an immediate solution from TRCSL. So we have routed it to cybercrime division, and they have taken immediate action. So it went well. I think the awareness is important in this area, especially for women and children and parents. And nevertheless, we described the process and approach person should take in a situation of being harassed online. This is an important, some people don't know what the action that they have to take when there is a harassment. So this is another area that we have looked into, and it is a continuous process, and we are keep on having all the awareness programs, especially in the social media. Even we don't have a role to play directly in this area, but we do much as possible as as a responsible organization in that and the telecommunications regulator. So those are the brief on TRCSL and about the social media, what we are doing. And the interesting thing is the current and future activities that we are at the moment, what we are doing and what we are planning to do. This will be, I'm sure, will be important to the members who are listening today and other professionals. So first one is it's a big topic in the town about the SIM registration. You all know and you all heard about this, the SIMs, and a lot of people have a lot of problems, different problems with the SIM registration. Especially the law enforcement authorities, when they are conducting investigations, at the end of the day, they will be landed with no data, no information about the SIM owner or the person who was or the victim or the accused. So information missing. So this is a very interesting and important area. So we have now we have gazetted the SIM registration is gazetted, and it's available even in our website. You can see this is the web gazette notification. It's available at TRCSL website. So it clearly says about how you have to register when you're obtaining a connection, and how the operators, this is mostly the regulations for the operators, but nevertheless, even the users, they have the equal responsibility of getting their SIMs registered. So guideline is there, the gazette is there, so the law is it's in place now. Only thing, people don't know much about or the requirement of a registration of a SIM and the responsibility vested with the owner of the SIM card. So we will be conducting in the mid-October, maybe starting from mid-October, we are opening a huge public awareness campaign for the general public to register with the operators about their particular SIM or the connection, telephone connection. I will say the telephone connection. So what we have to understand here is, once I have obtained a connection under my national identity card, so I will be the responsible person for whichever the activity is doing by anybody without even my knowledge, my SIM card. And it's all clearly mentioned in the gazette notification because of the time limitation of time for the presentation. But anybody is interested, you can visit TRCSL website and you can go through the SIM registration. So you can hear in another couple of weeks, maybe 1 month, everybody should get their SIMs registered. So we will be keeping loud on that. Then the second one is the national IMI database. The other area that we are, everybody is interested to hear. And this is not a new thing, because you have seen maybe in the papers from I think August, not August, starting from August, we have advertised about this national IMI database and the requirement to obtain TRCSL licenses for the people who are selling the IMI-enabled devices. And they have to get the license from TRCSL. So without the license, they can't import the equipment. Even the rule is there. The rule is there at the moment, but implementation is it's very difficult. You know, even though there's a law to obtain a vendor license for the selling of equipment, but there are a lot of people are selling equipment without the license, and mitigate all this. It's a difficult task. I had to be very honest. It is a difficult task. So what can we do? Like everybody knows, there are here and there are a lot of illegal imported phones, and most of the phones are with low quality or maybe not type approved, and health problems and some of the equipment people import different parts and they assemble here, and you have warranty issues. So a lot of things happen. So what TRC has initiated, we have initiated a process. There will be a common IMI database, which will, I'm sure, a big news for you. And we will announce very soon a particular day. From that day onwards, the vendors should obtain TRC approval, and they have to submit the IMI numbers to TRCSL when they are applying for the TRCSL approval. And these IMI numbers will be in a common database. So when a person purchases a phone or a SIM-enabled device, I will say SIM-enabled device, and insert a SIM card and try to make a call, if it is registered, your equipment will be working. If it is not registered with TRCSL, your equipment will not be working. So we will announce very soon, but then what will happen to there are different aspects are there. We are working on that. And especially, this is about the vendors. Then what about the individual people who are bringing phones or the IMEI-enabled devices from outside? So at present, a person can bring with him 5 devices under his passport or NIC. So they will be getting a SMS at the time of registration. So no need to come to TRCSL or any place. So they can then and there register their equipment. Then what will happen to the millions of subscribers with existing phones? Yes, we have taken care of that as well. So we will be announcing a particular time period for the existing people to register their equipment. So be cautious and don't worry about existing users. I want to make it loud. Don't worry about the existing users. We will be giving a grace period and we will be giving a time period for registration. But for the vendors, be careful. After the date that we announced, you are not allowed to bring the equipment if it is not registered with the TRCSL. So the third one is the Gamata Sannivedana project. Maybe you have heard, but maybe you have not heard. It's based on the manifesto of the government manifesto about the technology-based society. We have implemented this. We have identified, in fact, several areas without the 4G coverage. According to the manifesto, we have to have the 4G coverage in 2021. The whole country should cover the 4G. And give more detail on this. Sure. Yeah, right. Okay, fine. Got it. So we have identified that 4G coverage is not at acceptable level. So with the digitalization plan of the country, connectivity is a key factor where everybody should access to the 4G. And with this project, this Gamata Sannivedana project, we provide the provision of, it's the infrastructure facilities, especially wireless, it's 4G and the fiber for the fixed operators, and the infrastructure is the 4G for the mobile operators. And TRCSL, of course, conducted a survey in 6 districts and identified blind spots and coverage area.
Yeah.
Okay, thank you. So we have initiated the pilot project in Ratnapura. And the beauty of this is TRCSL also investing in this infrastructure. It's interesting. You know, how we are doing this from these, maybe you have heard about the Telecommunication Development Levy, when this will be charged from the international telephone calls. And operators have to pay some portion of the international call to the TRC as a Telecommunication Development Levy. So the total telecommunication development levy, the 50%, we have to pass it on to the treasury. Then the balance 50%, of course, we can invest in the rural development, rural telecommunication development. So with this project, the service providers, they have to provide the infrastructure given by the TRCSL, the areas and the locations, and they can reimburse the cost up to 60%, up to maximum 60%. So the guidelines are in place. We have initiated the pilot project. So we have identified the first 6 districts I think altogether 14,000 GS divisions we have identified. So we are planning to cover everything to be completed by 2021, hopefully, with the blessings of everybody, especially the industry and the stakeholders. So these are from the Gamata Sannivedana project. Then the other interesting topic is the 5G trial. Of course, that it was initiated by the spectrum was allocated on request basis to all mobile operators and fixed operators, but one fixed operator not requested the spectrum, but all the others are requested, and 1 or 2 operators they have initiated, they have started in 2019 the 5G trial, but not the full-fledged trial, because since we are running over the 4G network, you can't get the maximum out of it, but future to come. And we have seen there are, I think, 2,000 or 4,000 5G enabled mobile phones available in the country. So it's a very good move, and we are looking for that. Even I wish to mention here in this Gamata Sannivedana project, the infrastructure at the moment, like the operators are deploying all our 5G enable infrastructure. So when we are ready with the commercialization of 5G, it's easy for us to deploy the 5G. So then the last one is the number portability. Very recently, we have announced that people were waiting for the for the number portability. So conceptually, it was agreed by the operators and the regulator. We are working for a roadmap, and we are forming the technical committees, and it's geared. And we are planning in another 6 to 12 months. Hopefully, this will be in place. So these are the areas that I would like to share with the people who are with us today. So this is from my side, and I hope that it was interest for you. And I'm happy at the Q&A session that I'll be answering your queries. So thank you very much for listening my presentation.
Thank you, Madam Ms. Talika de Oliveira, for those insights and your presentation. Our next presentation is from Mr. Sunil Aberatna. Mr. Sunil Aberatna, a senior attorney at law, holds LLM from Queen's Mary College of University of London. He had his MBA from Indira Gandhi National Open University and Diploma in Forensic Medicine, Science and Toxicology from the Faculty of Medicine, University of Colombo. He's a practicing attorney at law in the fields of civil, commercial, and criminal law, and a commercial arbitrator. He's a visiting lecturer and an examiner of Sri Lanka Law College, Faculty of Law and Faculty of Medicine of the University of Colombo, Department of Law of University of Peradeniya, and also at the Bar Association of Sri Lanka. He has been appointed as a researcher of China South Asia Law Research Center, Yunnan University, Kunming. He was instrumental to strengthen relationship between Law Asia and Bar Association of Sri Lanka, organizing Law Asia ICT Law Conference in 2008 and Law Asia Business Law Conference in 2010 in Colombo, heading the organizing committee of the Bar Association of Sri Lanka. He served as a Law Asia Vice President during the year 2015 and 2016. And he was an EXCO member during the period from 2010 to 2015. He was the country councillor, alternate councillor during 2006 to 2010, and acting country councillor last year. Sunil headed the Sessions Committee of the Polar Summit held in Colombo in 2017 and represented the President of the Bar Association of Sri Lanka at the Polar Conference held in August 2018 in Canberra. Sunil has represented over 100 conferences and seminars, and he had submitted papers at national and international conferences, including Law Asia Annual Conference, IT Law and Employment Law Conferences, 800th anniversary celebrating of Magna Carta representing Law Asia, IBA conference, and contributed many articles to leading local and international law journals and to Sri Lankan press on ICT law, intellectual property rights, and employment law. He authored the book titled Introduction to ICT Law, and he is the chief editor of the Business Lawyer, the Law and Management Annual Journal. Currently, Sunil holds the positions of co-chair of Data Protection, Communication Technology Committee, and he's the secretary of the Employment Law Committee of Law Asia, and also an EXCO member of the Bar Association of Sri Lanka. And he's the chairman of Continuing Legal Education and Digitalization of Court System Program and course coordinator of the certificate course on ICT law of the Bar Association of Sri Lanka. And recently, he was elected as the EXCO member of the Organization of Professional Associations of Sri Lanka in 2018 and 2019 as a representative of the law profession. Over to you, Mr. Sunil Aberatna, to elaborate on the topic on legal impact on social media and telecommunication, the way forward.
Thank you very much, Mr. Dulitha, for introduction. After following Ms. Oliveira's presentation, they had a brief discussion while she was making the presentation. I will drop displaying my that slides presentation. I will just briefly, I will discuss what is the legal impact on telecommunication and the social media, because I think it will be easy, then you can easily follow what that Mrs. Oliveira explained. Mainly, I'm very happy the way that she made the presentation and that explained development of the legal provisions based on ICT sector. Why this that we have to learn about the legal aspect or legal impact on telecommunication and social media. ICT industry is developing. It's relevant to all professions, all business people, whether it's the large enterprises, medium scale enterprises, or small enterprises, and even the service sector, and even the leisure. Now, when we talk about the development of ICT industry, there are lots of areas involved in that. Mainly that we can see the development of electronic commerce today and mobile commerce. And when we take mobile commerce, now it has gone to cloud computing, social media, that big data, and artificial intelligence. Under these circumstances, now let's see what are the main areas that are relevant to law relating to the ICT sector. For our convenience, we can discuss this subject considering the time allocation, mainly based on these subtopics: computer crime, electronic commerce, and m-commerce, and intellectual property rights relating to ICT industry, and data protection, and employee-employee relationship under information society, and computer evidence and their forensic issues. Now, when we discuss telecommunication, Ms. Rivera explained in future that our authorities will take steps to register SIMs and numbers of the devices we import to the country. So considering these factors, what we can see, our legislature and the lawmakers, they are trying to avoid misuse of devices and network in the country, considering the law and policies introduced in other countries and the experience we got from the overseas. Now, when we take computer crime, while we are using computers and network, there are some people, they misuse these devices and network. If a person misuses the device or network, we can classify these computer-based offenses under 3 categories. So they are computer-related offenses, computer-integrated offenses, and content-related offenses. It's relevant to telecommunication sector, even when we are talking about social media, that we can apply this classification. Now, considering the nature and the behavior of computers and network, because this is a new technology to the world, all countries who introduce statutes relating to computer-based offenses. Now, take example in Sri Lanka, our legislature introduced a Computer Crime Act in 2007. The United Kingdom, their legislature introduced Computer Misuse Act in 1990. Likewise in Singapore, Australia. Most of the countries have already introduced this legislation. The reason is to identify the unique offenses relevant to computers and network, because we can't find these parallel offenses under penal codes of the relevant countries or any other statutes comes under criminal justice system of their jurisdictions. So considering that, of course, now take one example, the computer hacking, cracking, or computer modification, the computer misuse against national security, national economy, the public order, covered under our Computer Crime Act. And if anyone illegally upload, download any data, it covers under Section 7. And illegal interception of data, especially is relevant to traffic data. If someone takes our SMS, if someone takes our email illegally, it comes under Section 8. If anyone use some devices to carry out some computer-based offenses, it comes under Section 9. Likewise, we can identify, or otherwise they're relevant to service providers, their Section 10 under Computer Crime Act. After giving logon ID file and ID files and passwords to the service provider, without getting permission of the subscriber, that they can leak out to a third party. So likewise, we have identified the 10 unique offenses relevant to computers and network, because we can't find these offenses under any other statute. Now, this is the development of the country relating to the computer-based offenses. As far as the rate of this computer misuse in the country, this is very important. Unfortunately, that we can't satisfy with the implementation of this act, because we can find only 1 or 2 cases of filed under this act even during the last 13 years. Anyway, I hope that law enforcement authorities will take steps in future to bring these wrongdoers before courts. So this is our expectation. And the other area is electronic commerce or electronic transactions, because we have Electronic Transactions Act in 2006. When you discuss these electronic transactions, the electronic commerce is part of electronic transactions as far as the Electronic Transactions Act is concerned. Mainly when you come to Section 7 of Electronic Transactions Act, because Sri Lanka has entered into Budapest Convention, the Cybercrime Convention, and the United Nations Convention on International Electronic Contracts. After entering into United Nations International Electronic Contracts, our legislature brought an amendment to Electronic Transactions Act 2006. It's under Act number 25 of 2017. Now, according to new Section 7, because this is very relevant for the authentication of electronic document, it clearly says, it's a new section, where in written law provides that the communication or any other document shall be signed or bear the signature of any person, then notwithstanding anything to the contrary, in such written law, that requirement shall be deemed to be met in relation to a data message, electronic document, electronic record, or communication, if a method is used to identify that person and to indicate that person's intention in respect of the information contained in the electronic communication, and the method used is as reliable as appropriate for the purpose for which the electronic communication was generated, sent, or communicated. Now, as far as these new devices and the methods we are going to apply in future for electronic signature or digital signature, this is the expectation of the law in our country after 2017. If after placing electronic or digital signature for a document, it must be in a position to identify the authenticator and the intention of the authenticator. For that purpose, of course, we need some mechanism. It must be that technology or technical neutral mechanism must be there. We can apply various methods using the modern technology, but we can't find answer only through technical support for this aspect. The reason is there is no yardstick or there is no standard acceptance to declare that the particular system is the best system to recognize the authentication of an electronic document. So therefore, the Section 7 of Electronic Transactions Act will help to provide the minimum standard. This is the requirement. If any person can satisfy briefly in a judicial proceeding that the method used for authentication has fulfilled these requirements to identify the authenticator and the intention of that person, then that is enough. Now, otherwise, it is not easy to maintain this section. Now, I'm not going to discuss about in detail about the regulations and other laws relevant to telecommunication, since Ms. Rivera briefly explained what the intention in future, because I will take up on the two issues, two matters relevant to that. When we talk about computer misuse, then the data protection and the privacy policies will play a vital role. When we are having these electronic transactions, if the parties who are involved in transaction have no trust on that, if they feel that they will lose their personal data due to various reasons, then they will not carry out their online transactions. So one area is computer crime. The other area is that the safeguard of their personal data. Unfortunately, at the moment, we don't have data protection law or privacy law in the country. There's a draft Data Protection Act at the moment. I hope that the new parliament will enact this act very soon. As far as the general data protection regulations in European Union, GDPR had developed after experience with their data protection directive and getting some experience, especially from countries like Australia and Hong Kong. Based on that, the GDPR will be introduced by European Union. Now, as far as processing of data in cyberspace, there must be some protection. Now, there are the
මොකද එයාගේ ඉන්පුට් එක මේ මයික් එකෙන් ඇහෙන
GDPR has that introduced some principles. Now, they are mainly, the first principle is a lawful, fair, and transparent processing. So that the expectation is to maintain processing of data lawfully, fairly, and transparently for data subjects. Data subjects means the person who is the owner or who is in possession of that data. And the purpose limitation. One can use data for a particular purpose, specified, explicit or lawful and legitimate purpose only. and data minimization, that one can process data, applying the theory of the adequate, relevant, and limited to what is necessary about the purposes for which they are processed, and accurate and up-to-date processing, because data processors' duty is to maintain accurate and up-to-date processing. Limitation of storage in a form that permits identification and confidential and security and accountability and liability. So these are the requirements maintained under GDPR. Following this GDPR, we can see that our proposed act has been drafted. We can satisfy with the provisions under our proposed act. The one issue I would like to raise that here, even under GDPR, even under our proposed act, it says the public authorities can interfere with personal data. So that is why the India, at the moment, there's a big debate going on whether to follow GDPR or not. Because what they say is, even the public authority, if they enter into that personal data of the citizens, it can be a violation of their fundamental rights. So that we also have to keep in mind, if the public authority is given that unlimited that freedom to interfere with personal data, it can be a problem considering socio-economic political background of the country like Sri Lanka, because we are from Asia, because Asian politics are totally different to the politics in United States or European Union. So then our lawmakers, I hope that lawmakers will definitely think about this aspect. Other areas, intellectual property rights, even copyrights, patent rights, topography, and unfair trade practices. These are the main rights guaranteed under intellectual property law. After introducing the new act, Intellectual Property Act in 2003 in Sri Lanka, following a number of international treaties and conventions, we also have recognized the copyright, patent rights, and domain name rights, topography, that means layout design rights, protecting the integrated circuits, and unfair trade practices in Sri Lanka. So this is relevant to cloud computing, so the big data and artificial intelligence. Now, telecommunication has to play that big role there. Now, when you take telecommunication, they provide the medium to carry out communication. So there can be lots of data protection violations and intellectual property rights violations when people use this that medium, electronic media. Now, under this, I wish to discuss briefly what is social media and what is the legal impact on the social media. In fact, we must understand what is this social media before we discuss the legal impact on that. Now, this is we can say the social media, that internet-based means of communication. It's a platform to communicate and share information, and people-powered communication, connecting each other of an online community with common interests. Actually, it's an authentic dialogue. It's not a simple dialogue. It's an authentic dialogue. And online communications in which individuals shift fluidly and flexibly between the role of audience and author. So this was expressed by Joseph Thornsey, the CEO of Thornley Foley. And there are some advantages. What are the advantages if we involve in social media? Now, one advantage is this publicity to profile of the organization at a very low cost, carrying out market research at low cost, the promotion of goods, services of the organization, the better interaction with employees and customers. Now, take example, if a dress designer, earlier, that dress designer had to publish their new dress designs, paying a huge amount of money for some magazines, international magazines, or some using newspapers. But today, he can easily open up his Facebook page, and he can post his dress designs some pictures, he can release that to Facebook with a very minimal cost, and he can carry out his profession or service. He can give good publicity. In the meantime, he can carry out market survey. Once again, earlier that we know that people had to spend a lot of money to carry out market survey. Spending money to hiring some people to distribute some leaflets among people, sending them to the Fort railway station or bus stand or whatever place or their particular area. Or they had sometimes they posted a questionnaire to the new national newspapers, magazines, spending lots of money. But today that they can carry out their market survey using this Facebook. So they can promote their professional activities or services. Even that students who are sitting for advanced level exams or O-level exams, so they can, individual student can carry out their research work and they can share their findings with other students. They can save money. So this is what we did during COVID time, because this is one advantage we got of this COVID pandemic. Our people are used to they carry out lots of research work using computers, devices, and network. Even when you take social media, not only Facebook, MySpace, LinkedIn, Twitter, blogs, various that social media pages are there. Now, these are some advantages I explained. Now, let's see what is the misuse of social media by various people, especially employees. We have seen they misuse their social media. Now, there are some examples. Already decided cases are there because they have tarnished the good image of their own employers using social media, especially the Facebook pages of employees. Then there's a question arise, can the employer interfere with that social media used by employees that depend on the nature of the employment? Some countries have allowed, even European Union countries, the employer can demand for the logon ID files or password of their Facebook page. The time to time, employer monitor their Facebook. I will give one example, fine example. What happened was one of that employees attached to a big organization in EU got a sick leave. They got permission from the employer. After a couple of days, the employer used his Facebook the page. So the employers saw that the employee that who got the sick leave, he has posted some pictures into that Facebook that he was dancing with some girls in a pub on the same day. So then employee the next day, he terminated his services, they took the disciplinary action against him. The allegation was that the employee made wrong, false information to the employer. That's gone that far. So this is the culture developed in various countries, even United States. Sometimes judges and the lawyers who are appearing for both parties, sometimes they log on into their clients or sometimes opposing parties that social media, Facebook, and they collect data and present this data before courts, not illegally, but legally. Sometimes courts also give time to time, courts also give direction. So then that councils are entitled to log on to these social media, Facebook and Twitter, these pages. Now, anyway, especially the social media, you have to maintain equitable action. Now, as I explained you earlier, that if anyone involved in online transaction, he must have the trustworthiness. There must be trustworthiness on this transaction. It's relevant to social media and the other transactions as well, because there must be confidentiality, integrity, and the retrievability. So this is a balanced process. On the one hand, one can get the advantage. They can carry out various market survey. and they can promote their that professionals' activities or services. In the meantime, there must be data protection and the privacy of other people as well as the data subject. They have to balance this position. How to balance the position? So that is why we need data protection law. Now, what is confidence? This is another area. This is not mere confidence. There must be a quality of confidence. And there are some obligations based on confidence. Once again, contractual obligations are also there. All these matters relevant to social media and other electronic transactions. Now, there are some people who misuse this social media. This is a common problem in the country at the moment. The common problem is that sometimes they say that they possibly they posted some pictures or unwanted items to another person's Facebook account. So it can be sometimes hacking, can be a cracking, because otherwise without finding that secret data, secret details of that particular page, you can't just post the materials to their that account. So it can be a it can be an offense under Computer Crime Act. Or in addition to that, sometimes you can't say it's an offense under Computer Crime Act, but maybe violation of data protection. The parties are allowed to log on into the particular Facebook account, but after log on into lawfully that they will log on to that account. So thereafter, they will carry out various offenses. Take example, tarnish a good image of a person, disclosing some personal data to the rest of the world, like that. So that is why that we need data protection. The other side of the data protection of privacy policy is right to information. So at the moment, luckily, we have right to information law in the country, but not data protection. So in future, that we hope that we will get a good data protection law compatible to GDPR. The other area is admissibility of electronic evidence, compute evidence. There, of course, I personally am not satisfied with certain provisions under Electronic Transactions Act, because we have to develop that. Otherwise, it is not easy to bring electronic evidence before judicial proceedings. Because Section 21 simply says if there is no reason to disbelieve some computer materials or evidence, then prima facie it will be accepted the material. But you can't apply this theory, because we can apply this theory when we deal with paper-based document. Considering the nature and behavior of electronics or electronic medium, data message, electronic document, electronic record, or other communication electronic form, it is not easy, especially data of data, that's metadata. Metadata is changing every time, because it is not easy to apply any mechanism to accept this information inside the electronic document as genuine, because we have to find some mechanism, or we must introduce some special declaration. The person who produced this document before court, they must give some declaration to court. By this way, of course, we can balance this situation, that getting some experience from United States or United Kingdom, because they have fine mechanism, they have introduced various mechanisms to overcome the situation, and they have criminal procedure rules, civil procedure rules relevant to collection, that have the collection and for analysis and preserving of this data and producing before courts. So then we can follow the same, because we have our legislature has brought amendment to civil procedure code. Now we are applying a pre-trial stage in the civil cases. In future, that I came to know that they are going to apply some pre-trial matters for criminal matters as well. At this pre-trial stage, we can resolve this problem. So then that it is easy to produce the electronic evidence before court. If we can't bring this evidence before court successfully, then once again, it will be a barrier to develop the system. And other areas, forensic issues. Again, we must have the mutual cooperation, international mutual cooperation under this sector. Otherwise, it is very difficult to carry out investigations relevant to electronic communication. We have some treaties and understanding, especially that telecommunication regulatory that framework is there. Then authorities are there because they are members of the international organizations. So then they are entitled to share various data between these countries. Sri Lanka is also a member of these countries. The Commonwealth Telecommunication Regulatory that Commission is there. Likewise, even the Part 3 of Computer Crime Act explains the mutual cooperation, the relevant to the offences relating to Computer Crime Act. So this is how that we have to develop the system. Otherwise, every time that we have to carry out investigations, we will now take simple example. Today, the problem is when if a person complains that one third party has uploaded some clips to Facebook, the most difficult area is to find out where is this person, who is the real person who uploaded that. For that purpose, we need that international cooperation. Since we have entered into Cybercrime Convention, Budapest Convention, now we are also members of that convention. So we can get the assistance of other countries or member countries. So they have the obligation to assist other member countries to carry out investigations. So likewise, this the development we can see. What I can see is even the when you invite me to address on this, of course, on the legal impact on telecommunication and social media, what I can explain is we are going on this transit period of the development of these two sectors, telecommunication and the social media in this country. Most of the countries, they have developed their culture. They know how to use social media, Facebook, Twitter, and other accounts. Most of the people, they don't use this social media for the unwanted thing, but they don't misuse because they have passed that era. Because still that Sri Lanka, we are passing that area. This is the problem at the moment we have faced. Anyway, as Ms. Oliveira explained, hope for the future, because I hope that the legislature will bring, the minister in charge of this area will bring more and more regulation to strengthen this act. At the moment, we have only a framework of legal framework, Computer Crime Act, Electronic Transactions Act. In future, there will be Cybersecurity Act. Of course, there, of course, on the administration part, I can see there is no much involvement of cybersecurity there. And proposed Data Protection Act and Evidence Special Provisions Act and IT Act. So these are the main acts at the moment. But what we can see is these are the framework of legal framework. So we have to strengthen using introducing regulations and bringing various amendments of that. So briefly, this is what I can explain you. Without having legal impact, without having legal recognition of that, there are certain issues we can't resolve problems relevant to ICT industry only using technology. Of course, every day the scientists are bringing new devices, new methods for that network to the world. So therefore, if there's a dispute arise, if there's a difference, it is very difficult to resolve those problems using only the technology. So that is why we must maintain the minimum standards of legal provisions relevant to this technology, considering technical neutral. Technical neutrality is very important. So otherwise, it is very difficult if there is no technical neutrality maintained by any country. This is what other countries have done. So let's see that how we are going to apply these provisions in Sri Lanka as well, because computers are coming from other countries. Network is mainly, internet is common to all countries. There is no Sri Lankan internet, Indian internet, or US internet. Internet is internet. So if we use common devices and common network,
Mr. Aberatna, we seem to have lost you in between. Are you still on? Hello? Mr. Abhiratna, are you still on? Ladies and gentlemen, just bear with us. Mr. Abhiratna, you're back. There was a small window during which we lost your connection. Please proceed, Mr. Abhiratna. Over to you.
Point that you lost that. Because I didn't get that indication. Yeah. Yeah, Durita, that what is the point you got last? Hello?
Yes, sir.
Durita, can you explain which point, because you lost my connection?
No, in between, your video was suddenly stalling and we couldn't hear anything.
What's the time, how long that you could?
Just for about a minute.
Last couple of minutes.
Yes.
Right. Now, what I can give this message is, one can ask, what is the legal impact? Why these legal provisions we have to understand, learn, relevant to ICT sector? The reason is, if we are going to resolve all these disputes and issues relevant to ICT, applying only technology, there can be lots of problems. Because what is the yardstick to resolve various problems? Now, computers are that it is in international market. Even a network in that internet is relevant to all countries. There is no Sri Lankan internet, Indian internet, or United States internet. Since we are using devices in the common market, and we are using international recognized network, internet, then of course we must be in a position to harmonize the legal provisions with other countries who use computers and networks. So that is why that we must understand the legal provisions relevant to this technology. That legal provision we need, it must be technical neutral. That means technical neutrality. We have to maintain technical neutrality for that. So with that, we can build up the confidence of online users. So this is the message that I want to give you within this given time limit. Of course, this is what I could explain. I hope that you got some idea of the legal impact on technology, mainly telecommunication and social media. If you have any question, please, you are welcome to forward. Then I will try my best to answer your questions.
Right. Sir, if you have any other insights to provide, please proceed to do so. You have a couple of more minutes which you can take.
All right. Okay, fine. How many minutes you can give me?
About 7 minutes.
Right. Okay. Right. Now I will take that another area that the main issue here is most of that people they are asking that how to collect evidence to produce before courts or before tribunal or before arbitration. So these are burning questions, not only for lawyers, even the ordinary person, the company, this can happen. Now, take example. Today that we can see some item someone has posted, or video clip or picture, the tarnishing good image of a person, right? Likewise. Now, sometimes that the person that who has suffered, who aggrieved by this, of course, but he couldn't see that. He got this information through a third party. Now, when you log on to that, of course, by that time, the person who uploaded that picture also came to know that now you are trying to investigate the matter. He will remove that post. The question arises that how to produce this evidence before court. Now, how to trust whether when you go before courts. Of course, now that particular picture material is not there. Then can you, if that every time, can you hire an expert to produce this material before court. Considering cost factor, the country like Sri Lanka, can an ordinary person in a position to bring this matter before law enforcement authority or before judicial proceeding? This is a practical problem. But otherwise, that is why some Indian authors, they say, especially that e-commerce law, most of the ICT laws are relevant to electronic commerce. Now, when you come to electronic commerce, it's a commercial activity. Now, there are some business practices available here. These people this is not the only business they are carrying out, they continue this business. So then they have a background, the previous conduct is there, their intention is very clear, then it is easy to bring this evidence before courts, considering other circumstances. Now, if it is a paper-based document, the situation is different. Now, otherwise, you must get ready for it. Every time you have to maintain snapshots and keep it, but it is also impossible. So these are some common problems you would face when we use social media. And another area is that we call these contracts under social media or other electronic transactions. We have three types of agreement. One is shrink wrap, other one is click wrap, other one is browse wrap. So mainly shrink wrap is now that we have passed that era. We don't need to discuss that matter much. Come to click wrap. What is click wrap? Now, website will display terms and conditions about your agreement. Now, after going through these terms and conditions, then you have to enter into legally valid contract after clicking I accept button or I agree button. That's why it's called the click wrap. Browse wrap means sometimes they will give the URL, uniform resource locator, that you have to go to another page and read terms and conditions and come back to the main page and say, yes, I understood terms and conditions of this contract. In between, there are some exemption clauses. That means that e-tailer, that advertiser or the website designer, they want to get their hand washed from their liability. We call these terms as conditions as exemption clauses. So that means they are not liable because we, as a customer, we undertook to bear the losses or whatever it is. Now, that's another question arise. Considering the way the web designer introduced these terms and conditions, whether it's a reasonable exclusion or not, exemption clause or not. Now, this is simply, I can say, exemption clause, of course, come under law of contract. Now, there are some car parks. When you park the car, only you can see, you can park your car at your own risk. After parking the car, only you can see that. This is not that correct legal exemption clause. Then, of course, you must put up that board before you enter your vehicle inside the car park. So likewise, here also exemption clauses are there. So then that web designer must explain that, must give the fair opportunity to the customer or consumer to read. Now, countries in the European Union, they have distance selling directive and consumer protection directive. The customer rights are very, very powerful. Unfortunately, at the moment, we don't have such that powerful consumer protection law, especially in cyberspace. So we have to develop this area while that we are developing data protection and other telecommunication regulatory work. This is another area. Simultaneously, we have to develop consumer protection in cyberspace. So we have to go a long way. So one area we have to develop electronic commerce, bring in this relevant legislation. This is not very difficult task. At the moment, most of the developed countries, developing countries, even our neighbor country, India, even Singapore, Malaysia, all countries, they have applied this consumer protection, especially that relevant to electronic transactions. So we can get the experience and we can introduce this. Only thing that we must have a vision. So this is what I can give this message without giving this support, the legal support for this technology, especially to the ICT sector. It is not easy to develop even ICT sector or mainly the electronic commerce. If we can't develop electronic commerce in the country, we can't enter into international trade and commerce successfully. Then we will lose our revenue day by day. We will lose revenue. So we have to develop that immediately without any delay. We have to introduce this law, and we have to strengthen this ICT sector in the country.
Thank you very much, sir, for your excellent presentation on this topic. And there is quite a lot that we need to delve into. We have a set of questions that we got to ask you and Madam Harlika also. At this point in time, I would like to recognize our presenter who was unable to make it. I also tried to get in touch with Mr. Oshada Senanayaka. Unfortunately, he is still tied up. And we would like to show our gratitude to the DGTRC-Iesl for being able to provide us with a able resource who was very nicely articulated the facts and circumstances. And Madam, thank you very much for responding to a few of the questions that our members have asked in the Q&A and also in the chat box. I would like to take this opportunity to ask a few questions from you with regard to some of the matters you mentioned. One of the things that you captured in your presentation was the coverage that in our very small country, you got to have proper coverage, and there are still certain pockets in which we don't have data availability and connectivity. So we sort of welcome the initiative by the TRC-Iesl, giving some incentives to the operators to expand their networks into rural areas and making sure that the connectivity is available. You see, particularly taking into consideration of the COVID situation, how the children were affected, how the education was affected. Quite a few other people from Colombo and so-called elite crowd was able to continue their education while the rural community was left behind. One thing was inability to have access to data. The second one was not having necessary equipments to access. So in terms of TDC levy being provided as an incentive for the operators to expand into markets, the regulation wise, there was an act that was passed earlier, and it was later on the regulations came through that, and it was effective. Can you please elaborate a little bit as to the operationalization of this concept in the new context? You also said there was a pilot that has been initiated. Over to you, Madam.
Thank you, Dilita. This time I am not making mistakes, right? I have unmuted my mic, Dilita. Thank you, and before that, answering your question, I'm sure you will allow me, which I have mistakenly, I think I have not informed the people who are in this forum. We are of course struggling with the Act of 24 years old. So everybody knows the telecommunication is a vast developing area. So the act should be updated. So good to have that we have drafted the new act, amended the act, and it will be available very soon, which will cover most of the areas and all the technical developments which we could not include in the previous act and will be in the new act, especially in technological matters. So this is a thing that I forgot to mention you, which is very, very important.
Right.
And
so, Madam, has that act gone in for consultation at the public level?
It's in the legal draftments with them, but But it will be in place. Sorry, because I know it will be coming soon. I'm sorry now. In which stage, of course, I can't give you the proper answer because the proceedings, of course, I don't know. It has gone to the legal draftment, that I know, but thereafter, but my lawyers, the legal team said it will be in place very soon. So that's
Right.
all I can give you, Tulida.
Right. So, Madam, is there any possibility for OPA to deliberate on the contents of this act? I'm sure we have the Bar Association as a member body, and you do have engineers who are involved in this area, the ICT sector. If there is a possibility for us to review and maybe perhaps comment on some of the areas, if there is an opportunity, we would be more than happy to sort of get involved with the blessings of our, the process that we have internally.
Sure, Dulita, because I have to talk to my lawyers. So I will pass it, your question to my lawyers, and definitely I will respond to her. And if it is possible, we are happy to share with all the professionals here. So we can get a very good input from all the professionals who will be the affected people with this act, right?
Sure.
Including all the public, general public. So coming to a question about the Gamata Sannivedana project. Yes, why there is an aggressive approach for this project is it's a blessing of the COVID period, because we have identified, we have issued in some way we have managed to grant approval for different kind of packages, very attractive packages. Some are like, these are for work from home, then study from home, and even free of charge for all these, platforms, Microsoft platforms, Zoom and all, everything, MS Teams. But the problem was people even who don't have a connectivity or coverage for a 2G call, how can these peoples were neglected during those periods, and they could not attend even especially the students, we will say the students, the university students, they could not attend to their lectures. Even the people can't work from home because of this connectivity issue. So this I want to mention, the aggressive approach for this project is blessings of the COVID, and I hope that everybody is geared and everybody is in. This is one of the prioritized work in the TRCSL. And we are having every day, we are having consultations, technical teams together, discussing pros and cons and pluses and minuses, where we can improve, what we have to do, how to get the funds, and how to even, I want to mention here, the beauty of this is we are preparing a workforce and getting people from VTA, and we will train these people, and we will request operators to get their services. It will be fully local people who will be working in this project, especially on construction, and if even the, so this is one thing that I want to mention and I forgot to mention. And the other thing is the operators, it's mandated to utilize the government lands for the construction of towers. So the young people will get a lot of opportunities, and there won't be foreigners working in this project, and all these workforce will be 100% Sri Lankans. So these are, and the other thing is the areas that we have identified for the time being is Ratnapura, Kurunagala, Hambantota, Polonnaruwa, Kalutara and Matara. So 14,000 GS divisions we have identified, and sooner we will go to the other districts as well. And you can see we are working, the work is progressive aggressively.
Right. Thank you very much. I would like to draw attention of those who are already on the webinar to go through the chat box and the Q&A. But for those who may have any difficulty in accessing that, I would like to repeat some of the answers and questions. Ms. Tarlika has been very kind enough to respond to some of those questions. They are in the chat box itself. One of the questions that came through was to recognize, how do we recognize our device, whether it is registered or not? The response is type IMI, IMLI, is it? Mr. Arlika, it is IMLI space.
Can I explain, Dulita? Can I explain, Dulita?
Yes, please. Yeah, go ahead.
To check your device, even at present, we do have the system at TRCSL where you can check whether your equipment is registered with TRCSL. This was one arm that we have already introduced in 2010. So the expansion with the other arm will be introduced, which I have mentioned about this common database is an integration of TRCSL limit database and the operator systems together. So it will be an expansion. So at the moment, even you can check whether it is registered. You have to type IMEI. IMEI stand for International Equipment, International IMEI, Mobile Equipment Identity, IMEI, and keep space and type the 15-digit IMEI number, which is displayed. Either you can get it if it is an open box, you can, if you have the equipment with you, you can type *#06#. Once you type and send, then you can get the equipment IMEI number, or you can just remove the back cover. I'm sure most of the smartphones you can't remove the back cover, so definitely you have to type *#06# and you can get the IMEI number. And type IMEI space and type this IMEI number and send SMS to 1909. Then you will be receiving a message from TRCSL. It will say either it is approved or not approved. If it is not approved, don't worry. If it is not approved, you can call TRCSL and they will guide you what you have to do.
Thank you very much. Then there was another question. I would like to post it to Mr. Sunila Beratna. There was this question on, is there any law which directly or indirectly enforces on hate speech and expression of violence on social media?
Yes, I have already answered to him. Anyway, that I have typed and answered. Now, mainly, Sandulita, now when you take Section 6 of Computer Crime Act, it is very clear. If any person misuse computers or computer systems against national security, national economy, or public order, it's an offense under Computer Crime Act. Now, it clearly comes under public order. With the hate speech, if you can interpret that, it can be destruction of the peace, that the maintenance of the communities in the country, or there are we have that experience, bigger incident and Berual incident, we have that experience. The people posted some unwanted materials to social media. Of course, our law enforcement authorities should have investigate, and since we are keeping this this laws that we actually what we did was we blocked social media. We don't need to block the social media because we have legal provision. It's in operation from the year 2007 under Computer Crime Act. Even it's an offense under Penal Code as well.
Right. Now, there is this growing concern, the digital devices, which are smart devices, are being used by people of different ages, both minors as well as majors. One of the questions that comes in, there is teenagers and young generation who is using a lot of smart devices. And if they commit any act of hate speech, violence on social media platforms, how would we deal with such situations? Are there any laws, regulations that governs that aspect of it?
Now we have the Penal Code Amendment in 1995. They are Dulita for limited purpose. As far as the development of ICT sector, of course, it is not easy to deal with that issue. Now, considering child pornography, of course, that we can deal with that provision. If any person keep in possession of child pornography for the purpose of distribution or exhibition, it's an offense. A picture means maybe electronic or otherwise. In addition to that, now it's an offense. What you call me that child abuse in cyberspace is an offense under Budapest Convention, Cybercrime Convention. Sri Lanka has already entered into that convention. Now, I hope that lawmakers will use this opportunity and introduce in the future. Now, in United States, the superpower, they haven't given 100% democracy for all people in cyberspace, though they are superpower. Now, they have COPPA, COPPA Act, relevant to the protection of children in cyberspace. Even the small children, sometimes they can't get email account without getting the permission of their parents. Now, the service providers it's a duty, it's an obligation of the service provider to give parallel line to the parents. In addition to that, if children, if they misuse or if the other people encourage these children to misuse devices, it's also covered under that COPPA Act, COPPA Act. You just type COPPA to your Google search, you can get the entire act. This is not the time to discuss all these provisions. This one solution, because solutions are available in other jurisdictions. Only that we have to analyze this and bring that relevant provision to our country, fitting into our situation, considering our socio-economic and political background.
Thank you very much. Then there was this question which you had already responded, I suppose. Under which act child pornography and cyber harassment can be charged? For the benefit of those who are involved in the call, under Penal Code Amendment Act number 1995, it is an offense under Cybercrime Convention. And as a country, I think we have to introduce this as an offense under Cybercrime Act in the future, is what Mr. Abhiratna indicated. Do you have any other comments to make, Mr. Abhiratna, on that?
Paul, issue is we have, at the moment we have to go for an interpretation because that Penal Code Amendment Act is a picture. In Rex vs. Fellow, that's a decided case in United Kingdom. They decided what is the interpretation for picture. Because some argue this and picture means that the normal picture, drawing or painting, that is what inside our mind. But picture means not only drawing or hand paint. Picture means including digital images. So this is the declaration given by that court. So we can apply same theory here. Anyway, after delivering that judgment, that UK Parliament immediately they took step to amend their act and bring new legal provisions. So this is high time that we also to follow Budapest Convention and introduce this offense.
Then there was this question of buying online, where one was questioning how safe it is. And one example was given, if an item received where you buy it online and damaged or in poor quality, or if the trader engages in any cheating, is there any way to claim damages without going into or going through the court system, because the amounts involved may not be significant enough for you to go through that legal process? Would you like to elaborate a little bit? You had given a short answer, Mr. Abhiratna, but
I have already answered that question.
Yes,
personally,
I know.
But it is not easy to answer. Give me a couple of minutes, I will explain. Now, in European Union, they have distance selling directive. Distance selling directive. It's black and white, it's clear. It's especially for online transaction. Now, if any person or any organization, if they display their goods or services, they have to give the minimum details. They have to display that on the website. They have to give the geographical location of the organization, their contact details, dispute resolution mechanism, whether if there's a dispute arise, whether that parties can prefer this matter for arbitration or for mediation or the system, what is the place for arbitration or mediation or negotiation. That mechanism is there. Unfortunately, we don't have distance selling law in the country at the moment, though we are in only online transactions using internationally recognized devices and internet. So we are also part of that internet, but we don't have that law. So that is why this is one that alarm signal I can give, that our online users are not safe. They are not safe. If something happen, of course, then they have to apply their individual contract agreement, their terms and conditions of the agreement. If there's a terms of that conditions in their contract, then of course that is party autonomy. That means that a wish of the parties, they can apply their terms and conditions and go ahead with the dispute resolution. So at the moment, this is the problem, because this is not the safest system, because it is very difficult to draft all for each and every application. You can't put all terms and conditions. There must be general principles of law. This is what we are lacking at the moment. The only solution at the moment, your own personal agreement, terms and conditions of your personal agreement, and Consumer Affairs Authority, that act. But Consumer Affairs Authority Act was not introduced not only for electronic contracts, electronic transactions. It is for the common purposes. Considering the nature, behavior, and speed of electronic commerce, my personal feeling is it is not enough.
Right.
So
You
keep in
feel
mind,
there is a lot of reforms that need to come through.
Especially
Right.
distance selling that directive, we have to follow that, and the consumer protection directive in electronic contracts in EU.
Right. Thank you very much. I would like to now, since we are sort of coming into the close of the session, I would like to now turn to Ms. Lanka. There are two questions. One of the things that is happening is social media is through digital platforms, and these typically uses data connections. Now, sometimes some of the social media platforms are people use, which are popularly being used, are being blocked. And then in order to circumvent, people use VPN, and they still continue to use those facilities and move in. Is there any mechanism through which, as the regulator, TRCSL could take action? Number two, is there any other way in which TRCSL could regulate this?
Blocked by whom, Gunita?
Sorry, Naren.
Blocked by whom?
Oh, right. Okay. I'm not too sure. There is, we have seen we don't know who has blocked it, but there is obviously people talk about it.
There are mites, but it's like this. TRC is engaging in these activities when the jurisdiction is there, when there is a clear court order for us to carry out not only this, any activities related to social media, we are bound to do that. That is the law in the country. That is the law in the country. So, and clearly mentioned that we are not regulating, and we don't have intention even to block anything, which is a powerful tool for the people. So it's very clear. I have to loudly say that, because TRC is considering social media is a powerful tool for people to express their views. I will say, like, even especially the social media, why we need the social media is for the enhanced outreach and real-time engagement and individual interaction. So TRC will not block for sure unless we receive a clear jurisdiction or a court order to do so. And other thing is TRCSL doesn't have any mandate to regulate social media.
With regard to VPN, access through VPN, is there any way in which TRCSL can regulate or manage that?
None of the organization in the world is regulating VPNs.
Okay.
No way. Technology is that.
Right. So the next question, it was on Gamata Sannivedana program. How are they being initiated and implemented? You said a little bit about it. Would you mind just elaborating in a minute or two? You had also responded to that question which was raised on how you're encouraging local entrepreneurship and involvement of local people. If you can elaborate a little bit on Gamata Sanvidenia, what are the different projects that are there and how it is going to get captured?
I think, Dulit, I have already explained, and I have explained everything, but different projects in the sense, like within this project, it's a collaborative project by operators and the regulator, and this will be done by the constructions and infrastructure development is done by the operators, especially in the coverage, bridging the gaps of the coverage and providing the 4G, like 4G accessibility geographically throughout the country by 2021. You can't say it's hypothetically, but it will be achieved with the help of everybody. And again, I have mentioned about the workforce and about the funds, how it comes. But more you want to know, like if you can specify which area you would like to know, then I can elaborate on.
There was this question which was raised.
Yeah.
You had also summarily responded.
Yeah, that question, because there is no inside project within the big project, because I did not understand that question. She was asking about the projects inside of this big project. I don't know, I didn't get the proper question, so I have answered, but she said okay, so I thought maybe, but I have mentioned she agreed with that.
Right, okay. So thank you very much, Tarlika and Mr. Sunil Aberatna. With those remarks, we will close our session, and I would like to invite our General Secretary, Ms. Ruchira Gunasekara, to do the vote of thanks. Ms. Ruchira Gunasekara is a lawyer by profession. She obtained her Bachelor of Laws degree from the Open University of Sri Lanka and her Master of Laws from the University of West London. And she has a Master's in Human Rights from the University of Colombo. She's also the Vice President of Sri Lanka Women Lawyers Association. At OPA, she held the positions of Assistant Secretary, Vice President, and she is currently the General Secretary of OPA. And she is the first ever lady General Secretary of the OPA since its inception in 1975. So we would like to proudly say that we have brought in the inclusion and diversity into the organization of professional associations by having the first female General Secretary in our organization. So over to you, Madam, to propose the vote of thanks of this session and to conclude the session. Thank you.
Thank you, Dulita, for kind introduction. Thank you, Dulita, for your kind introduction.
of me, and good evening to everyone. On behalf of the Organization of Professional Association of Sri Lanka, I take this opportunity to propose vote of thanks to those who have directly and indirectly contributed to this webinar on legal impact on social media and telecommunication way forward, jointly organized by the social events, outreach programs, and young professionals of the OPA and the Electrical, Electronics, and Telecommunication Sectional Committee of the Institution of Engineers, Sri Lanka. At the outset, I thank our eminent panelists, especially I want to thank Mr. Oshada Senanayake, Director General, although he could not be here today for this webinar. His initial contribution and his advice to us, especially to our committee, in organizing this webinar. We are very thankful to him. And of course, to Madam Mrs. Taralika Livera, Director Compliance of Telecommunication Regulatory Commission of Sri Lanka, Mr. Sunil Aberatna, Senior Attorney at Law, the Chairman, IT Committee, Law Asia, and the Co-Chairman of the IT Committee of the Bar Association of Sri Lanka for their participation despite their very busy schedules and for making excellent presentation, sharing their valuable knowledge with us. So I thank all of you once again for your time and knowledge sharing with us. I would like to thank our chairman, the chairman of the Social Events, Outreach Programs and Young Professionals Committee of the OPA, Vice President, Mr. Dr. Naresha Samrasekara, for his committed, I should say, effort in organizing this webinar and to make it a reality. So thank you for your contribution again. A special thanks and sincere thanks to our Assistant Secretary and the co-convener of the committee, Engineer Chamil Edrimuni. He is also the chairman of the Electrical, Electronics and Telecommunication Sectional Committee of the Institution of Engineers of Sri Lanka. For again, you know, actually he initiated this webinar, so we are very thankful to you and grateful to you for your contribution. And also I want to thank my colleague, my sincere thanks to Mr. Ruanta Kure, Attorney at Law and the Director of Telecommunications Regulatory Commission of Sri Lanka for coordinating with the Office of Director General for organizing this webinar for us. And also I want to thank our moderator, Mr. Dulita Ferreira, who is a partner of KPMG, Chartered Accountant, and also he's the EXCO member and the forum member of the OPA for his valuable time, effort, and contribution. I would like to also thank our President, Mr. Saman Varusavitana, office bearers, distinguished past presidents, chairman and chairperson of standing committees, members of the Executive Council, and the General Forum for their advice and the support in organizing this webinar. I also special thanks to the members of the social events, outreach programs, and the Young Professionals Committee for their support and coordination in organizing this webinar. Our sincere thanks to our audience for their active participation. I appreciate the hard work of the OPA Secretariat staff headed by Mr. D.N. Senduratna and his active staff for their support. Now, I'm also thankful to the International Institute of Knowledge Management for providing excellent technical support for this webinar. So I again wish to extend our gratitude to all others who supported us in numerous ways in making this webinar a great success and a reality. So thank you all once again. Good night.